Judge. Nice to see you.
Yes, sir.
Appreciate you coming up here.
Absolutely.
Again, I'm Mike Sasso. I have the privilege of being the chairman of this commission. And the protocol will be each of the commissioners will introduce themselves. We have one commissioner appearing on the speakerphone. After the introductions, you'll have 2, 3, 4 minutes wherever you need to give a little opening statement about yourself. We'll then have about 20 minutes of Q&A. I get to be the bad guy and call time, probably in the middle of something interesting. and then you'll have 2 or 3 minutes to make a little closing statement if it's appropriate. So let's get started.
Good morning, Your Honor. Vincent Citro, the law offices of Horowitz and Citro.
I'm Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Bardos with Gray Robinson.
Mike Sasso of Sasso and Sasso. Let me introduce Commissioner Amanda Perry Carl, who's on the speakerphone.
Good morning.
Brett Renton with Schutz and Bowen in Orlando.
Good morning, Your Honor. Pedro Brownlee with the Brownlee Law Firm.
I'm David DeArmas of Kramer, Price and DeArmas in Orlando.
Your Honor, Scott Thomas with Byrne Foreman.
All right. Well, first, if it's my turn to speak, I want to thank you for the opportunity. I know that you don't have to interview everybody that applies, and I certainly appreciate the opportunity to speak with you about the position. Next spring will be my 35th year as a lawyer. And the beginning of my 9th year as a judge. I practice law in a very complicated area of the law, and I was good at it for the better part of 27 years. As a judge, I maintained my involvement in the things that I was good at as a practicing lawyer, but I've also been assigned in virtually every division of the circuit court. And in every place I've been assigned, I have succeeded. I've managed big dockets, I've dealt with big cases, I've written important orders. For the last 4 years, I've had the opportunity to teach my colleagues, which I think puts me in a little bit different position. It certainly helped me. Preparing to teach your colleagues is a big deal in my mind, especially when it's 500 circuit judges. So it gives me, as a practicing lawyer that specialized mostly in death penalty litigation, you had to stay on top of what was going on in the appellate courts. You had to understand what the existing opinion said. You had to be able to anticipate where things might go in terms of being able to practice in a courtroom. I now teach other judges a mandatory class on the death penalty. It requires me to be even more up to date on what's going on with the law and to be able to sort of look ahead and see where things are going. My research and writing skills are 1,000 times better than they were when I left law school, and I certainly didn't claim any expertise in that when I left. But from my practice and my time as a judge, I think at this point I'm qualified for this job. I know that I can do it, and I think I can do it well.
Your Honor, I'm going to start if it's okay.
Yes, sir.
Maybe as a sort of first principle, do you have what you describe as a judicial philosophy? And if you do, how does it manifest in your service as a trial judge and prospectively on an appellate bench?
Well, the law says what it means. I've been dealing with statutes my whole life and cases that apply those statutes. I haven't spent a lot of time in a general civil practice, that has a core in the common law. Criminal law, obviously, is statute-driven, and the cases that I dealt with as a criminal lawyer are deal with that issue. But I think the public should be able to read a statute, understand what it means, and that a judge's job is to apply that law. And if I can't figure out what it means, then it wasn't written properly and should not apply. As far as a judge philosophy, I try to be prompt. I try to be prepared when I come to court. I don't get to the bench in the morning and say, okay, what are we doing today? I already know what's on my docket. I've already looked at the motions that I'm going to hear. I try to be polite, but I expect the lawyers to be prepared and to be respectful, and I give back what I get.
Well, I can tell you, in having the opportunity and the pleasure to talk to a lot of folks about you, some references and a lot of lawyers who've appeared in front of you, you don't have a mistaken impression of yourself. I heard often about the great hard work you do in the preparation. One of the things that struck me particularly was from both the prosecutors, the defense lawyers, was sort of a shared praise for how you handle capital cases. I heard death is different, and because death is different, and I did commercial civil litigation, I've never done criminal work in my life. They tell me that
That would terrify me to do one of those.
that judges can lose control of it, whether it's the idea of what's at stake or the certainty of appellate review, and they both sides praised your ability to keep those kinds of capital cases on track. Do you have something you can share with us about how you particularly handle capital cases and what that may say, if anything, for larger view as an appellate judge?
Well, I think I benefited greatly from the fact that I started as a defense attorney. And my first capital case was as an assistant public defender representing a gentleman charged with a capital murder all the way through the penalty phase of the trial. So I've had the opportunity, for 3.5 years as a public defender to be face-to-face with people charged with offenses like that. So it kind of shaped my whole viewpoint of everything, even as a prosecutor. I left the public defender's office a little bit out of frustration that I could not completely do what I thought was the right thing as an assistant public defender. I could point out where I thought things were done improperly. But I saw pretty quickly if I went to the other side, I would have considerably more autonomy to do what I thought was the appropriate thing. And I worked for a man for 27 years that trusted me to do that. He didn't question my decisions. We talked about them because he's the boss and he has to hear what I'm going to do. But I take all of that experience with me to the bench. I've tried a capital case on the defense side, and I've tried more than 20 of them as a prosecutor. So I understand how that trial should work. I understand what the level of appellate scrutiny is going to be. I understand what the Supreme Court doesn't like hearing coming out of lawyers' mouths, and more importantly, what they don't like hearing coming out of judges' mouths. So I think the fact that I had the opportunity to do both has helped tremendously.
Well, if I could just one more follow-up, and then I'll let my colleagues chime in. What would you say, certainly you've had a cross-section of work on the bench, but how would you address any concern if the commissioner had it or if the governor had it that you didn't have sufficient civil experience to, because Fifth DCA, the vast majority of their cases are criminal, but the majority of their actual written opinions are not criminal.
Right.
So how would you address that concern or potential criticism?
I see it as a welcome challenge. I actually have been assigned as an associate judge in the Fifth for next month, in just about exactly a month. And I'll be on a panel with Judge Orfinger and Judge Sasser. And one of the cases that I'm assigned, I've managed to get in and start looking, is a foreclosure attorney's fees issue, which as I start poking at it, realized it's going to be a big deal because the Fifth District issued an opinion within the last year or so, interpreting some cases from South Florida. And now the Fourth DCA, within the last couple of months, issued an en banc opinion directly addressing the Fifth DCA's case, certifying a conflict with it, and creating a situation where I'm going to be assigned to a case that has a raging conflict and the first opportunity, as far as I can tell, for the Fifth DCA to actually address what the Fourth DCA is saying is a conflict between the two positions.
Well, welcome to the party.
Yes.
I guess it speaks well you didn't withdraw your application.
No, I'm glad I looked at it early, okay? But I'm absolutely excited about the idea of kind of getting into that and tearing it down and figuring out where it needs to go. But I'm very much looking forward to that.
Thank you, appreciate it.
Judge, having a background in capital cases, do you think that the majority in Hearst got it right?
No,
Why not?
which one?
Sorry?
The Supreme Court?
The United States Supreme Court, the original.
No, because I believe the Hearst decision is the product of the living Constitution point of view. Because if Ring meant what it said, Ring said Florida was fine. It was in a footnote, but for 14 years, we've handled death penalty litigation with the understanding that Ring said Florida's scheme was fine because of the hybrid portion of it, that there was a jury recommendation, but that the judge was the ultimate sentence. So I don't think, I think what they did was predictable, but I don't think it was the result of what I would consider an appropriate way to deal with precedent.
When you say the result was predictable, what was it that you
So-
saw that said, I saw that decision?
Apprendi, when Apprendi was decided, then everyone involved in capital litigation, you start looking at the other precedents, and you wait on when and how the Supreme Court is constituted and where they may go with those kind of issues. Apprendi was clearly a precursor to what we were going to see from Ring as a result of Ring, and Apprendi is the reason that they did what they did in Hearst.
Judge, your application, and maybe I missed it, you said you had served in every division of the court. Was that in here?
Yes, sir.
How long were you in the administrative judge?
For 2 years in Marion County. Yeah. I ran against our current chief judge and lost, so he moved me.
When you say that you have taught in death penalty, have you ever taught at life over death?
No, I went to that when I was an assistant public defender. But I'm on the faculty of the Handling Capital Cases course that's required by the rules of judicial administration. There's 6 of us, sometimes 7. But I've also taught in other areas, the circuit judges, just general criminal areas, sentencing, things like that. But I've recently been adopted on the faculty of the Handling Capital Cases course.
For what organization?
It's it's OSCA sponsored, but the rule requires the course begin. The rule,
This is
Really?
for judges?
yes,
Okay.
for circuit judges. The rule of judicial administration requires every judge that's assigned to a criminal case to have participated in this class, and then every 3 years to sit through a refresher course. So we teach the main class, which is 4 days long, and then a day-long refresher each year. So the judges kind of cycle through that are assigned to death penalty cases.
Judge, if let's just say I were to pull every decision of yours that you may have rendered and that was appealed up,
Mhm.
right? And I take a look at all of them, and there are a lot of them, right?
Right.
What do you think should be the takeaway that I would be left with by looking at those decisions that are reversed or sent back?
The ones that I have had sent back, I've had a couple sent back dealing with pro se litigants, that they didn't like my approach with the pro se litigant. And I understood why I was reversed, but sometimes being there creates a different situation than trying to read it from the record. I got reversed one time in a dependency case because there was a time standard not met that nobody mentioned at the time that I entered the order. And of course it got appealed, and oh, this thing didn't happen in 10 days, and it got sent back automatically. I think the takeaway from all of them would be that sometimes in terms of dealing with people, that maybe I don't fit in the box as tightly as I can, especially with process. Process are very difficult. Because I try to explain to them what's going on, and so it's very difficult to kind of navigate being the judge and not letting the pro se litigant trample his own rights, and especially in a criminal case. I think if you looked at the entire expanse of the appeals that I've had, you're not going to see many opinions because I'm usually PCA. I have been asked by the state to overrule the 5th District Court of Appeal. That's one of my writing samples, which is an interesting decision and order that I wrote, because I ultimately decided that they were probably wrong because they didn't get the right information, but they told me to do something, so I'm going to do what they told me to do. So, but I think that I care about what I do. I don't make reckless mistakes. The mistakes that I have made are generally very technical, and you know, when they come back, it's like the pro se ones came back. The guy never wanted to, well, one of them was because I didn't do enough for right here. And the guy didn't want a lawyer. He hadn't had a lawyer for 15 years and made it clear he didn't want a lawyer. So when he came back, I went through the whole Ferretta thing again, and you know, I don't want a lawyer, and then I gave him the same sentence again because that's what he wanted. So anyway, I think that's where it should.
You mentioned PCAs in
Yes.
your response. What's your general view on it? Well, you may have done some as public defender. Have you done any appeals where you were the lawyer, primary lawyer on the appeal?
No. That always went to somebody else to deal with. So.
And so, given that, so you haven't received one other than as a judge, but just give me your general views on PCAs.
Well, I'll, as a practicing attorney for 27 years, the use of that device to avoid problems, I think is wrong. You know, when we really can't figure out what's going on here, so we'll just PCA and leave it alone. When there is a genuine issue of law that should be commented on, it should be commented on. So, to the extent it gets used to manage dockets, I wouldn't sign up for something like that. If there's an issue that needs addressing, then I would be inclined to write, even if I was the only one writing. And even if I was in general agreement with what the panel decided. So there's a sense, I think, amongst lawyers that things get PCA'd to clear dockets, and that's disturbing. I wouldn't ascribe to that.
Did you say that you ran against the chief judge?
But he wasn't at the time. Our chief judge resigned. She did her 2-year term and didn't want to do it anymore. I have a great deal of respect for her. I think she did a terrific job. And I tried to talk her into running again, but she didn't want to do it. But no, and I ran against the other judge mostly on principle. There was an issue that we were trying to work through, and he had a materially different position than I did on it, pretrial release. And I was really concerned if he became the chief judge that any effort to reform or at least investigate our pretrial release practices would go by the wayside. And then I wrote my little letter announcing I was going to run. That's what I said I was running on. And then he beat my pants off.
What was the issue? Yeah, what's the issue on pretrial release?
Well, the Second Circuit is still in the throes of an ACLU lawsuit filed in federal court over their pretrial release practices. They operate off a bond schedule, which looks exactly like the one that we have in the Fifth Circuit. The presumptive tool for pretrial release is monetary bond, and it has been that way for as long as anybody can think of. It's the same thing that was going on in Tallahassee and in the Second Circuit. There is a tidal wave of movement across the nation on the issue of pretrial release and shifting from a monetary bond base to something that's a little more directed at the defendant and the risks the defendant poses. When we started talking about investigating, the possibility of moving away from monetary bond amongst the administrative judges, what I was getting out of him was, well, it ain't broke, so there's no reason to fix it. And I said, I suspect that's exactly what they were saying in Tallahassee before they got sued, and now they got a federal judge in open court saying, this looks pretty unconstitutional to me, what they're doing. So I'm still trying to push the effort as much as I can, but I'm not the administrative judge in Marion County anymore. So thankfully, the one he appointed supports the idea of investigating non-monetary procedures for pretrial release. And I think we're on the cusp, at least in Marion County, of being able to adopt a program that pretty much shifts the monetary bond where it should be. I mean, in the statute, it's the last resort. And that's the problem, is it was the first thing chosen versus the last thing chosen.
What's your view on interpreting a statute on the role of legislative history from a judge's standpoint?
From a judge's standpoint, it's pretty much useless in terms of trying. I mean, if I had absolutely no idea what they were trying to do, I might look at it for the entertainment value of looking at it. But in terms of looking at it to decide what the words mean, then if it's that bad, they fail. If it's that bad that I can't figure out exactly what it is that they intended to do, then that statute is toast. And it is kind of funny to read it sometimes, the legislative history.
There's no supervision.
No, and it's everybody's opinion. It gets really funny. So because you have these partisan opinions start filing reports.
Anybody else? Okay. Well, Judge, we all appreciate you coming here this morning. And if you'd like to make some closing remarks, we'd love to hear them.
I just, again, wanted to say thank you. I'm glad I got here on time for this one. So I'm a little calmer.
I don't remember you ever being late, so don't worry about it.
Yeah, it was bad. It was bad. In fact, I was teaching a class and got sidetracked. At any rate, so I'm a lot calmer today than I was the last one, because I don't like being late. I think, I said what I believe qualifies me for this job in my own. It's important to me. I've never had a job, but I did do the best I could possibly do at. And, when I walked out of law school, there were probably not many people that thought I would succeed at the level of litigation that I chose. I had one lawyer in a law school class tell me that there were plenty of jobs for lawyers that couldn't go to court. And I wish I remembered his name, because I'd like to look him up now. Because I've spent my entire life in court. But I think I'm prepared for this job. And I know I'm a little older than some of the candidates who have been appointed recently. And I'm 15 years older than every one of the recent Supreme Court appointees. But with age comes experience. And I think I have a level of experience in a complicated area of the law that has honed my tools for doing this job, if I'm fortunate enough to be nominated and selected. And as I said, I've never taken a job I didn't try my best to do, and that's how I will approach this. And I can assure you, if you saw fit to nominate me, you wouldn't be embarrassed if I was appointed.
Thank you very much, Judge.
Thank you.
Thank you, Ron.
Have a good day.
You
Yeah,
too.
It's that door.
Yeah.